Good afternoon, my name is Alina Shaltsova. I'm an immigration attorney from New York. In today's video, I'm going to share with you the most recent immigration news. USCIS policies, including policy on how to expedite your pending application or petition. I'm going to talk about certain important developments in immigration courts. And of course, I'm going to mention some other important developments and news in immigration. Specifically, we're going to talk about STEM students and how a STEM student may self-petition themselves for a green card in the United States. So thank you very much for joining me. Again, Alina Shaltsova, immigration lawyer. I help immigrants from all 50 states and those who are overseas as well. You can easily find my information on www.shaltsova.com. here as well, and on Facebook. New York Immigration Lawyer is our Facebook page, which is very popular. Please join us. Once a week, I do live presentations on YouTube and Facebook, during which you have an opportunity to ask your one immigration question that does not require tons of background information for free. So thank you very much for joining, and let's start. Well, first of all, we're going to talk about very important policy on when USCIS may consider a request to expedite a pending application or petition. For example, it's very relevant for those of you who would like to expedite their work permit or travel permit or perhaps an employment petition. And recently, USCIS updated its guidelines on when and how it can be done. Well, first of all, one can expedite their case if they can convince USCIS that failure to grant that petition or application is going to cause severe financial loss to a person or corporation, or that request to expedite the benefit is in the United States interest. For example, it's filed by the government, local, federal, state government, or, for example, request to expedite is connected to an urgent humanitarian reason. USCIS in the recent updates to its policy clarified and provided some examples as to when and how those requests are being adjudicated. Specifically, they stated, for example, that just because the request is filed by the government entity, it does not mean that it's going to be expedited. I found it very, very interesting. They also stated, for example, that humanitarian reason usually would relate to an illness, disability, extreme living conditions, death in the family, or critical need to travel. Perhaps examples of that would be, let's say, a person seeks expensive medical treatment that is unavailable in the United States and they must travel overseas. Very often, such a medical treatment will be maybe an expensive surgery of some sort, or perhaps even an organ transplant. Sounds crazy. Mind, however, that a desire to go on a vacation does not serve as a good basis for request to expedite. And this is specifically mentioned in USCIS policy. Just because you would like to travel to go on a vacation is not going to have your case expedited. Another example, when it's appropriate for someone to request to expedite the benefit would be a job loss. If you already have a job and you can show, perhaps with the company's letter, that in case you do not present an unexpired work permit, you will lose that job, your request should be expedited. Your request to grant the authorization. Very interesting. However, if you just would like to receive a work permit and you don't have a job, this is not a good reason by itself to have your case expedited. So there is a difference, right? Another example that USCIS provides is to expedite work permits for those who work in the healthcare industry at the time of COVID pandemic. We knew that already, but that's interesting that they specifically mentioned this particular example in their new updated guidelines. And of course, they also mentioned about non-for-profits that may, on your behalf, for example, submit requests to expedite your travel document. Imagine somebody is working for a university or non-for-profit and there is a need to travel overseas to participate in a conference or represent your university or your organization in some other capacity at an international event. This will be a good reason to expedite your travel document. Finally, what's not going to get expedited? Petitions and applications where a premium processing is available, according to USCIS, generally are not going to be considered within these guidelines. And one more interesting point from this new guidelines is that, according to the guidelines, if a person is in removal proceedings, USCIS will cooperate with ICE to expedite the petition or benefit they're seeking. And if you dig deeper, you will see that according to the guidelines, it should take USCIS no more than 45 days, or they strive to resolve the issue within 45 days if ICE requests USCIS to adjudicate a pending application or petition. Well, it's very interesting because from what I've seen so far, it takes USCIS far more than 45 days to adjudicate a petition for someone who is in removal proceedings. For example, someone is in removal proceedings and is married to a US citizen, and they need to go through this I-130 interview for the person who is in removal proceedings to be able to file adjustment of status application. Trust me when I tell you that it takes currently more than a year to go through the process and not 45 days. Of course, this timeline is probably affected by COVID, and I hope it's going to go back to 30 to 45 days goal that is voiced in the manual, but currently, unfortunately, this is not the issue. Another practical point. If you are seeking to expedite something that's pending, you have to show that you acted diligently, meaning that you did not wait till the last possible minute to file for this benefit. In practice, I find this point considered very often by USCIS, even though I didn't really see in the manual that specific mentioning of that specific point, that they're going to look at your entire timeline in the United States and see when you filed for that travel document. Could you file for it months ago when you first learned about your desire or about your need to travel, or you just relied on the fact that you can expedite it at any time? So this is one of the points that USCIS usually is looking at when they're adjudicating your request to expedite your work permit or to expedite your travel document. Another important news and change that we're seeing right now relates to STEM students in the field of science, technology, engineering, and mathematics. Very important, Biden administration expands or adds 22 new fields that will qualify for STEM designation. It means that students in those particular fields will be able to receive additional OPT training or employment authorization after their graduation, which currently stands at initial 12 months plus 24 months. J1 students in particular are going to receive or double their time when they will be able to receive STEM-related OPT extension from 18 months to 36 months. And also it's going to be a little bit easier to qualify for such students for self-petitions. One has to remember, however, that when they are filing for adjustment of status based on an employment category, they have to demonstrate that they maintained their lawful non-immigrant status in the United States throughout their entire stay in the United States, or they fall into one of very narrow exceptions to this general rule. So STEM is a good option for somebody to try to get a green card, even if they do not have a job offer, but they can demonstrate that their proposed activity in the United States will be to the benefit of the United States and in the national interests of the United States. Finally, I promised to talk about an important case that just recently came from the Board of Immigration Appeals, matter of La Para. In that case, Board of Immigration Appeals stated that if a respondent receives a notice to appear that does not have date and time, but later receives a notice of a hearing that does have date and time, and the respondent is being removed by default because he or she did not show up in court, then such a respondent cannot reopen their case. This particular case is very important because many of you perhaps were planning on or are in the process of having their motions to reopen being filed or pending with the Board of Immigration Appeals or Immigration Court based on Nis Chavez case that came in 2021 from the United States Supreme Court. And in that case that came from a high court, the high court or the highest court stated that a defective notice to appear cannot count as a legally sufficient document for certain legal purposes. And of course, the advocates were using that particular rationale for other legal purposes to argue that their clients should be afforded an opportunity to cure their default now because their proceedings were started with a defective legal document. But Board of Immigration Appeals currently disagreed, and if there is no appeal, this particular ruling is going to affect many cases. So check with your attorney if you're one of those persons who may be affected. It may be relevant to you if you did have an order of removal that was issued because you didn't attend your immigration court hearing. Well, thank you very much for watching. I hope you found this information helpful, or at least it may point you in the right direction if you are doing your own research. And of course, you're always welcome to give us a call and consult. We do have availability for private confidential consultations. They are subject to the fee, but if you would like to ask a free question, please join me during my live presentations on this channel and on Facebook. Thank you very much for watching, and I hope to see you soon.